thank you everyone for coming. Welcome to KHQ's Crisis and Reputation Management Forum. KHQ is a top-tier boutique firm. You know that. Many of you work with us closely and are very close friends of ours. KHQ has a number of different values which set it apart from others. One of them is to try new stuff. Another one is to build understanding with clients. And the third one is to have a plan. So what we're trying to do tonight, and some of you came to our event last year where we had a mock regulatory examination, is to really bring your experience with legal issues to life. Some of you may have experienced some of the things we're going to talk about tonight, and some of you may be hoping you'll never experience some of the things that we're going to talk about tonight, and most of you will probably sit somewhere in between. So the idea is to have, we don't want to bore you with slides about provisions and cases and things like that, although we may talk about them along the way. We want to talk to you from our real life experience, from different perspectives, different aspects of the law, different issues that you're likely to face in a crisis type scenario, and hopefully give you some food for thought about how to go away and think, what can you do to prepare? Now, you don't want to spend your whole business preparing for crisis, but you do need to think about it and you do need to take some steps. So hopefully tonight will, in a fun and innovative way, give you cause to think about how you might, I wouldn't say risk-proof your business because you can't do that, but take steps to at least be prepared, and that's the underlying message. We're going to try and stick to a fairly strict formula, and we're going to go through a number of scenarios so that you can sort of develop the life cycle of a crisis, of how it might play out, and again from different legal perspectives. I won't talk for too long. I just want to introduce the A-team, for those that remember the A-team. At the end there we've got Alex, who is a data privacy and cyber expert. Alex has acted for large and small companies in the UK and Europe, and now practicing in Australia, and heads up our team. And I don't have to tell some of you in the room about how important data issues are and how they play out, and what kind of disaster scenarios can happen. I'm not looking at anyone in particular. Then we've got Charles. Charles is one of Australia's leading food and regulatory experts. If you want to know anything about what's in any food you ever eat, don't ask Charles. And Charles sort of operates from the regulatory side, and we sometimes operate from the litigation side when things get a little bit hairy, and some of you in the room also have had personal experience with that as well. And we've got Claire, who is an employment and industrial relations expert, who's going to talk to us about some of the employment issues, whistleblowing, investigations, the tricky stuff. I think that's Claire's specialty, isn't it? Crisis. She loves a good crisis. We all do. And myself, Yuri, I'm a litigator, commercial litigator, with a strong background in class action and reputation management. That's a real interest area of mine, and we do the range of commercial litigation and regulatory investigations and the kinds of things that you might come across. And it's my great pleasure to introduce our moderator tonight, and we are grateful for her taking out her time and joining with us, Gabby Crafty, Senior Counsel. Gabby practices in commercial litigation with a particular focus in insurance and construction, and in the 2025 Doyle's Guide she's listed as a leading senior counsel in infrastructure and construction. So we are really, really privileged to have Gabby here tonight, and because of her background, particularly in the insurance space, she comes with a real understanding of how you can deal with crises and how they play out in the courtroom. So without further ado, I'm going to introduce Gabby.
Okay, so I'm going to paint a scenario for you, and you might think it's entirely fanciful. It's actually, as I'm told, based on a real life case that presented itself. We're going to start almost at the end, and then go back in time to work out how on earth did the client get here. So, allow me to regale you with a tale. Your company, for example, called Wellspring, manufactures and distributes supplements and medicines. One of its newest and most exciting products is called Acidel, which is an indigestion remedy which is produced as a gummy bear. But something goes wrong with the marketing of Acidel gummy bears. We're going to come to that. But where it all ends up is in a class action. A class action's been commenced against Wellspring, in which there are allegations of privacy and data breaches. And separately, the regulator has commenced direct prosecutions. It's fair to say the proverbial has hit the fan. Yudi, can I invite you to make some introductory comments on what on earth your clients do if they're at this stage?
Hopefully, you're not fully panicking by now. The reason for that is because you have, over the journey till you got to this place, as we're going to see in the earlier scenarios, you've engaged the right team. Part of that will be your lawyers, and you've made sure that throughout you have the utmost control. Nobody ever has control, and in these situations it's very difficult, but as much control as you can gather and maintain. Because if at this point everything else has happened and you're going, we need to find lawyers and we need to put our case together and we need to see what to do and do we have insurance, you're in a bit of trouble at that point. Because everything that's come up to that point will lead towards, no doubt, there's a lot of plaintiff law firms in this city, there are litigation funders, they will smell blood in the water, and some of them are very sophisticated and very good at what they do. Some of them are new players and really want to make a name for themselves in the market, and they will smell blood and they will come at you as an opportunity. And so you don't want, the first time you are putting your team together and worrying about what documents you have and what documents you may have created in a panic that may or may not attract privilege at that particular point in time. So if you want to maintain maximum control, as we go through the scenarios, think about what you can be doing to make sure that you are managing your risk, managing your people, managing your resources. Because class actions are resource heavy, they're a distraction, they are terrible for your reputation. You don't want to be there, and as some of the people in the room know, it's not a great place to be.
Charles, is there anything at this point that you want to add, or shall we keep going?
Yeah, we're starting at the worst point, but I think if anyone has been involved in any kind of crisis, and as much as we are going to be talking about prevention and being prepared, I'm sure you can talk a lot to this, Alex. Crises can just happen to the best prepared people. The best prepared people can get hacked. The best prepared people can employ someone who might be inappropriate in the workplace. I've had clients in international supply chains who suddenly there's botulism in their supply chain which had nothing to do with them, but suddenly they are wrapped up in this. But what I hope everyone takes from today, and in my experience in regulatory, is it's not just the class action lawyers who smell blood in the water, but it's often regulators as well. So I have one client who put a product to market that didn't go well and is currently interacting with the Queensland Department of Health, Food Standards Australia and New Zealand, the Therapeutic Goods Administration, the Office of Drug Control, Australian Border Force, and the Australian Taxation Office. And all of that started with one issue. And then that issue then revealed another, and then another, and then another, and then another. And so these things can cascade well out of hand. And I think, Yudi, your point, like the whole reason this is called a crisis and reputation event is actually Yudi's instigation, that it's not just about handling the crisis, it's not just about coming out of whatever's going on in the best possible light. Your reputation moving forward is super important. Like when hepatitis C was found in blueberries imported from China, people didn't buy any blueberries. It wasn't just the blueberries from that brand or that company. So to me it's your reputation isn't just with your brand, it isn't just with your shareholders or stakeholders or with your employees, it's all of those things. And my particular practice area is about reputation with regulators, because even if you resolve that whole crisis, are you going to come out of that being audited every 2 weeks or something that's just completely economically unviable because your reputation has been destroyed?
Okay. It feels a bit gloomy. and there may be more, but ultimately we are going to get to a happy place. And that is, you're going to walk out of here feeling uplifted and prepared.
And there's drinks afterwards.
And there's most importantly. Okay, so how did we get here? What went wrong? A person named Zoe Davis took some of the Acidel gummy bears. Unfortunately, her bears had been laced with a traditional Amazonian medicine, a jungle pigeon regurgitated crop milk, as well as a hemp extract. She wound up in hospital. She was seriously unwell. When she recovered, she complained to Wellspring, and she also went to the press. She also got some legal advice. And I just stop here to say what Yudi said is right. There are a number of traditional class action law firms in this state, but there are a number of new entrants into this space as well. Increasingly so, and more litigation funders. So it is a space that is ramping up, and I can come back later to why that is so. So she goes to one of these firms, and they assist her. They, on her behalf, file a data access request under the Privacy Act. So Wellspring springs into action. It initiates an internal investigation, and its initial findings reveal that Ms. Davis had been targeted based on her health information and had received free samples of Acidel. So I might start with you, Alex. Can you pick the eyes out of what I've just raised, perhaps with a bit of a focus on health data and consent, mailing lists and so on and so forth?
Yeah, sure. So obviously using health data for targeting is an activity that requires prior consent, and presumably this hasn't happened here because this person is suspecting she might have been targeted. That's why she filed the access request to find out more. And yeah, it's just a bit suspicious about how she's the one receiving a free sample out of nowhere from this company she never heard about. So naturally she would go for the privacy right of access, and it can be a quite powerful right. There are many exceptions to it, but essentially you are entitled to see what personal information the company holds about you.
How does it work, Alex? Like how does a customer, for example, use that right in respect of a private company?
So you just send them any kind of communication asking them for a copy of your personal information. It's as simple as that. It can be done in any shape or form. You don't even have to use specific legal language. You can just say, can you just tell me what information you have about me? And yes, the company then has to go back and think about, do we have personal information about this person? And this is where the kind of legal work starts, because often there are some targeting techniques where it could be perhaps targeting a household rather than the individual. So you could have an argument this is not personal information in that sense. It could also be that you have purchased some kind of mailing list which was already curated for you, and you no longer have the list because after the campaign it goes away, or it's held by a third party. You don't have access to it. You don't have any control over it contractually or otherwise. So there are many different scenarios that could happen. With all the privacy-preserving technologies, you can now achieve targeting in a privacy-preserving way, basically not getting hold of the personal information necessarily. So it will really depend on the circumstances whether the company can actually positively provide the personal information and potentially avoid, disclosure under the access request. So it can become quite technical.
Okay. Alex, can you weigh in here about health? Sorry. Charles, can you weigh in? Sorry.
Absolutely can, but I'd love to ask Alex a
Yes.
question, because a lot of the companies I work with are innovative startups, and so they're often buying these marketing leads. Can they potentially be exposed to liability and privacy from purchasing unknowingly from a third party?
Yes, I think so. I think the regulator has demonstrated that what they try to enforce the Privacy Act. The objective of the Privacy Act is to protect people's privacy, and so if a company is trying to circumvent the rules by saying, "Oh, we don't hold this. This is not personal information. We didn't really target the person, but the household or the street." We didn't send a direct communication to this person, but rather a letter, or made some other way of non-direct. I think the regulator will be quite keen to try to hit it on them still, because they are the ones instigating the whole process, and they are ultimately the reason why this person has received this targeted communication. So yeah, I think there's a lot of legality in interpreting the privacy rules, more so in Australia than I've seen in Europe, to be honest, where you have much more clarity about what personal data means. Basically everything is always personal data, whereas here it's a much more open concept. So yes, they could incur liability. If you're buying any data, you need to do your due diligence, you need to make sure contractually you're covered, and you're buying it from a reliable party which has done their which has obtained proper consent and all that.
Hopefully we've sufficiently scared people in the room about when they're buying marketing lists. When I heard your name Acidel, that you come up with Gabby, I loved it, because I've been trying to think of what would an indigestion gummy be called, and every name I came up with I googled and already existed as a brand name out there, so well done.
Does that involve litigation already?
One of the things, like, we're at the really early stage, and in my practice, as much as I'm food and beverage regulatory compliance, more and more I just find myself specializing in innovation. People only fork out a whole lot of money to ask me a question when it's something that they don't know if they're allowed to do it or not. And then there's a whole lot of people out there, maybe such as this company who's selling this product, who haven't even bothered to ask that question in the first place. And even if someone doesn't end up in hospital, I work in a corporate and commercial team. They're selling, young, exciting new businesses or raising capital for them. If the foundation of your business, of your offering, is illegal, that's a problem. It's one that you should identify as soon as you can.
People get excited by an idea, don't they?
Oh, absolutely.
And then it's like, well, I've seen this.
One.
Yeah. And they've been to a fair or somewhere and seen this product, and they haven't seen it in Australia, so it's like, let's just do it, and they're selling it, and then...
Yeah. And innovation is exciting. And you go, well, if I'm not harming anyone, it should be fine, right? But it may be that no one else is doing it for a reason. And I mean, the one thing that I'll throw out there is that Australia is a really weird jurisdiction from a food, medicine, cosmetic perspective. We're different from the rest of the world. So there might be products in the rest of the world that are completely legal that are here not legal. So like the easiest example I give is if you've got like rosemary oil or lavender oil and you're selling it as a massage oil, it's a cosmetic. If you're selling that to be added to a sauce, it's food. If you're then selling it as an aromatherapy product that helps your infant sleep, it could be medicine, right? It's the exact same substance. And a lot of people can't grasp onto why that should be, and frankly there's probably not an actual good reason, but encourage people really early on, if you've got an innovation. Like, I work with a gentleman at the back who works in financial securities, who comes up with all kinds of creative ways of delivering financial services. I don't understand a single one of them, but what I do know from all my practice areas is where there's innovation, it is worth investing in just finding out what your risk is up front as early as possible.
Just on financial services, I'm just veering away from Acidel and Davis for 1 second, and just to translate some of what we're talking about into, say, financial line space. So, like, there are some people here who are involved in superannuation, other financial services products. All of what we're talking about is applicable in that realm as well. So I recently advised a client, a fairly significant financial institution, about a claim it was making on one of its liability insurance policies for coverage in respect of its response to an investigation launched by the regulator. The regulator had detected that there was one line in a product disclosure statement for one of my client's products, financial products, that was a bit of a furphy, and no one's really sure how it got in there, so I'm told. And cut a long story short, the client had to acknowledge contravention of the relevant legislation and copped a whopping penalty. Couldn't make an insurance claim in respect of the penalty, but could in respect of its defence costs. And it could also in respect of its the costs dealing with the investigation by the regulator. It also had to engage in a very substantial remediation scheme to remediate customers. And it was seeking indemnity under its own professional liability policy in respect of, as I say, defence costs, but also crisis management expenses, which was covered by its relevant policy. And so this is my long-winded way of saying, after tonight, go back, speak to your brokers, make sure you're covered adequately for crisis management expenses, and that it forms part of your professional or just general liability indemnity policies, because one line in a product disclosure statement or one creative moment of innovation can end up in a whole world of pain financially if you are not adequately covered. That can be very problematic.
And for regulator, insert ASIC, ACCC, ABRA, Food Sense,
Fair Work Ombudsman.
and it'll all operate the same way, and you will be under a barrage at that point. So, and I think for the insurance question, how often do people run into things and then don't go, well, are we covered? And you may not be, and you may not want to call on your insurance premium's sake, and you may not want to be driven by the insurer because you've got your own reputation management. A lot of companies self-insure for that reason, but you should know what your position is, and you should have those discussions with the brokers up front and make sure you understand your coverage.
Absolutely.
I guess, just to add to innovation, equally targeting someone on the basis of their personal information sounds very enticing. You can make a better mark with customers by knowing who you should target, who will buy a product. But yeah, in the kind of health data space, it's quite risky, because even if you had a direct relationship with this customer and you knew what their potential health problems were based on their orders of medication, that's also health data used for targeting, so you still need that consent. And this is something that a company didn't realize in the UK, for example, and that they received a massive fine for it. They didn't have any policies around it. They just didn't really know, they didn't put their mind to what was going on, and that's something that the regulator doesn't like. I think similar rules would apply in Australia on that.
Yes, and across a number of spectra, I should say, not just food and beverage, medicines, supplements, but financial financial products as well. Okay, well let's move on to, we'll move on in the timeline. Following the press coverage, a whistleblower within Wellspring speaks out about the company's poor quality assurance and privacy practices and unfair employee performance monitoring. The whistleblower also reveals a recent data breach following system infiltration by an unknown attacker. Claire.
Hello.
Hi. What now?
Yes. So we now have a whistleblower complaint, and so there are a number of protections for whistleblowers that are going to be enlivened under the Corporations Act, and a number of things that we need to be certain that we don't contravene. The thing I think is most important to understand in relation to whistleblower complaints is the people who are going to receive the whistleblower complaint need to know what they can and cannot do with a whistleblower complaint. A member of your board receives the whistleblower complaint. It says, hello, I'm Jenny Bloggs and I work in the accounts department and I'd like to blow the whistle about all these certain things. And that member of the board forwards it to the CFO and goes, Jenny Bloggs has made a complaint about your department and you've just contravened the protections that whistleblower has. So everyone who is eligible to receive a whistleblower complaint needs to know how that might come to them and what they can do with it when it gets there. How it comes to them is in all kinds of weird and wonderful ways. So we've seen, burner Gmail addresses that someone has sent an anonymous complaint. Someone might ring up a member of the board and say, you don't know me, but I'm so-and-so, so-and-so, and here's what I'd like to tell you. Or a colleague of mine and I had a matter last year where it was a bit like something out of Get Smart, where the whistleblower left notes on people's desks that said, go look here. And then there was a folder. And I was like, you open the locker, and I kept envisaging that there would be someone's head that would go in the folder. This is a whistleblower complaint for you. But the member of the board or the member of your leadership team who receives that needs to know what to do with it. The two key protections that your whistleblower has are really, one, the confidentiality of their identity, either if they are anonymous, which is obviously going to restrict what you can do, or if they say, yes, I'm Jenny Bloggs, but I don't want you to tell anybody that's me that's made this complaint. Someone will go, anyway, it's Jenny, and you've got all sorts of problems. There are some exceptions to that. We can write to Jenny and say, Jenny, would it be okay if we talk to so-and-so, so-and-so? Jenny can consent. We want Jenny to consent in writing so that we can point to that and so that we've complied with our obligations in that regard. Or we can seek advice about whether or not the complaint falls within the Corporations Act provisions and what we should do, i.e. legal advice, and in that context. Otherwise, your board member can go to your CFO and go, I have a whistleblower complaint and this is what it says, and let's talk about what to do with it. But they can't say, by the way, it's from Jenny, it's just 2 desks over. Let's go talk to the employment lawyer about sacking Jenny. Because that's the second thing we can't do. So there can't be any detriment or other retaliation towards our whistleblower because they are a whistleblower. Now, sometimes that's a really fine distinction, particularly if Jenny says, hey, just so you know, I've been fiddling the books for a whole lot of times and I want to blow a whistle and have a get out of jail free card. Terribly sorry, Jenny. I'm not going to terminate you because you've blown the whistle. I'm going to terminate you because you've been fiddling the books. But that's sometimes where that line is can be quite tricky.
Okay. Alex, from a privacy perspective, what steps would you be taking at this point?
So typically there would be, I think, a policy on whistleblowing, how the data should be protected, how it should be handled. So I guess that's one aspect of it. But the other one is that this is something that no business can really protect against or anticipate. So if you're trying to deal with a certain problem in a certain way by not being entirely honest about what's gone on, there could be a whistleblower at any time coming out with some further information that will totally undermine your defense. And thanks to whistleblowers, we know about what Meta is doing, what Amazon is doing, listening to people in their households using an Echo device. The Tesla is watching people's faces as they suffer accidents in their cars, and I mean, some of it may happen for good reasons, legitimate reasons, but we would never know if it weren't for whistleblowers. So particularly in privacy, whistleblowing is almost like a celebrated thing to happen for the privacy community, because that's the only way for us to know what's going on inside these big technology companies. So that kind of leads to the conclusion, perhaps, that you need to come clean about privacy infringements, because it's too risky to try to spin things in a certain way. I think it will depend on the facts, but.
So getting ahead of it once it's come to the attention of the company.
I also heard the keyword policy.
Yes.
From a litigation risk management perspective, there's nothing better than you can do. It's like, when's the best time to buy real estate? 20 years ago. There's nothing better than to build your defence than having a policy. Now, it's not always adhered to and things go wrong, but if you have that policy in place which says this is how we operate and aim to operate, then that stands you instead that you've actually, and if you've been following that and things go wrong, well, it's much harder to slot it with liability. So that's a key word that I heard there.
The other thing that Alex said about getting ahead of it is important in your employee communications as well, because no one's better at making up a good story than an employee who hasn't been told what's going on. And there will be, gossip a go-go in your business, and it's too late at the time of the crisis. And often we're advising in a crisis of, someone's just resigned in their exit interview. She said she's been sexually harassed by the CEO of the business for the last 6 months. Awesome. Those kinds of things are happening. At that point in time, it's too late to go, okay, so who's going to talk about why the CEO is not at work because we've just suspended them while we're investigating this. So you want, we've got God forbid, we've got a fatality on our work site, and it's too late to be going, right, who's going to communicate to who. So you want a plan about when there is a crisis, who's doing what in terms of the communicating and where does the message need to come from. And often, my clients will say to us and our team, we want it to come from the MD, or we want it to come from the CEO, and that's fantastic, and that's, who the motherhood statement or the overarching message should come from. But all of those messages have a line at the bottom that says, something like, if you have any questions, please talk to your line manager. The line manager needs to know how to answer those questions, and we need to be clear that the answer that people are getting is consistent, dependent upon who their line manager is. So having a plan of, who's going to send that message. With our unfair employee practices, if we're a unionised business, they'll be knocking on the door. Who's going to manage their right of entry? Who's going to manage communication with those stakeholders? And if we're engaging with some sort of communications consultant or PR type organisation, sometimes they're great. Sometimes they're good at spinning a story which your employees will see through and go, something else is going on here because this just reads like a load of crap. I would often say we can engage the PR provider or we can review the PR provider's communications, because equally you don't want the PR provider to say something like, those who have brought this matter to light will be held responsible. And you're like, great, we're going to persecute the whistleblowers. Great, awesome, thanks for that. Just making sure that, with the best of intentions, they might say something like that, which is not necessarily going to help us down the track.
And those comms are going to come out as well.
Oh, absolutely,
so
yeah.
It's not just an employee stakeholder discussion, it's
the whole world discussion, yeah. But
when you get to litigation, that's going to be discoverable.
100%, yeah.
Unless you've done it in a privileged way, which can be difficult, but everybody rushes off to write internal emails and let's go after that person and we didn't know, and then they'll get some legal advice, and then someone will be sending that around to everyone saying our lawyers are saying it's okay, or our lawyers are not saying this. So if it's just haphazard, that'll see the light of day, and there's your reputation management issue down the track.
Or a text message from one board member to another that said, I always knew something was off about this bloke. Right.
Yeah, no text, no
text,
no.
But even outside of a crisis, like I've done due diligence recently for a food business that was selling, and they had a complaints register. Amazing. Massive list of complaints, and anyone who's run any kind of like physical product business will know you get mountains of complaints. We had one person who melted their own teeth by completely misusing the product. It's not necessarily your fault, right, as a company, but
Sorry, how do you melt your teeth?
let's say you've got like actual teeth. Let's say you've got a tooth cleaning product that says rinse immediately, and you leave it in overnight. Yeah. Anyway.
One of them white teeth.
Yeah. Yeah. Point. Oh, this register had nothing but complaint, well documented, but didn't say how any of them were dealt with or resolved. And it could have been that this company had an impeccable record and no issues whatsoever, but in due diligence you've got someone looking to buy the business and all they're seeing is a cascading list of problems without any idea how they were resolved. So
But we see that in our and in the regulatory space, or particularly in the workplace behaviour space. Someone will come and talk to a manager and they'll say, "Oh, I want to tell you about Charles and how awful he is, but I don't want you to do anything about it." And the manager will diligently take notes, and then they'll go, "Oh yes, we know. We have a whole folder of complaints that have been made about him." No, we haven't known about this for 12 months and done absolutely nothing to protect the safety of our employees, surely. But sometimes it's, "Oh no, we wrote notes." Good. So yeah, I'm not saying don't write it down, but I'm saying do something about it when you write it down. Yeah.
And document you doing something about it.
Yeah.
And finally, I'm going to throw to Yudi, perhaps, I'm not sure if it's relevant at this point in the scenario or if things are going to get worse or not.
A little bit.
Oh, they are? Okay. But then you want to, if this is part, if this documentation is part of your, and it's not yet a crisis, just part of your documentation of something going wrong or a complaint or really early stages, got to have some kind of assessment as to whether that should be privileged or not. Do you want, it's good to document these things.
Or if it can be.
Yes.
Yeah, indeed. Setting up, and when we talked about investigations from a privacy perspective, we talked about investigations from a workplace perspective, making sure that you at least give thought and your people are thinking that we need to try and set this up in a way that we can get the fearless advice that we need, but that we're not giving that up and it doesn't become a weapon to use against us. I've often heard of privilege being used as a shield, not a sword, and often sort of people go, "Well, our lawyers have said this," and throw it out and we're okay. And I had a case recently where I said to someone, "Don't do that.
Yeah.
Don't put in every email, and when the people are potential claims against you and you're writing down, our lawyers told us we don't have a problem here." So it's being thoughtful. I think that's the main thing you can do, is being thoughtful. If you set up the communication either with your internal lawyers in a way that it's clear that it's around an issue that you're facing, and or your external lawyers, then you at least are able to subsequently claim that document is privileged and not have to hand that over. You may not win that, and you may, but you've at least got a basis for saying we did this in a structured, protected way. We've got that bubble over us that allows us to do the things that we need to do internally, rather than just sort of throw everything out there.
And having any kind of process that you should follow when there's even the glimmerings of a problem, just in my experience, the companies that have those processes in place, it stops it escalating. Or if it is going to escalate, it's not because of what's happening internally in the business or someone's firing up the wrong email or...
It's in the hand of someone who knows what they're doing, or at least can think what they're doing, rather than it just being everywhere before you can contain it.
And I would just echo what Silvia was saying about do something about it, because if you hold personal information, particularly damaging to a person, and you have no reason for holding it, you're not doing anything about it, there's a privacy issue.
All right.
So you need to ensure personal information is accurate, and you need to have a reason. So it's just sitting there and there's no clear purpose for it. It should be deleted, really. So there's an argument it could be part of the employee record exception, this amazing concept of the Privacy Act. But it would have to be directly connected to a disciplinary action. If there's none, then why are we holding that information? So that could be another issue.
I haven't thought of that one, but we can add that in too. Okay, so Wellsprings conducted an initial investigation, but then its more detailed findings revealed that Wellspring in fact did not have a policy in place about the use of health data in targeting prospective customers. In fact, the sales team had been completely unaware that health data was being used for targeting. And that's because Wellspring was using a US-based marketing platform that offered mailing list enhancement and profiling capabilities. The US marketing platform didn't hold any consent records. Wellspring's general manager had been told about the unsolicited marketing risk associated with the external marketing platform, but had told the internal sales team by email to proceed irrespective.
No!
Yudi, what now?
Well, you've created your bomb, basically, and that's really why it's so important to be careful around that, that communication and the way the communication is controlled, your process, being calm about it, making sure that you know what documents are created around, because you know that ultimately those documents will be produced in proceedings when we get to the litigation and class action phase afterwards.
Claire, is a more detailed workplace investigation required at this point?
I think the key words in that question are "at this point." So probably yes, down the track. If we're in the middle of a regulatory investigation, my question is often, do we want this person in the tent or not? So are they, are they on a job of their own, and we're going to get them some separate legal advice potentially, and maybe have some sort of an exit discussion with them, or do we need to continue to have them involved in the defence of the matter and have them in the tent and have them in that arrangement? So that'll be a question that we're often asking. Often we will do what I call an HR investigation, i.e. has this person engaged in misconduct, not necessarily from the legal or the regulator perspective, but have they done things that are inconsistent with their obligations to us as the employer, and we might do that afterwards. So I recently did one after a regulator prosecution and a court case and findings that were against the organisation. We then went back into the individuals and said, right, Buglugs, what did you do? And I called them Buglugs throughout the whole investigation. It was super professional.
Is that a defined term?
Yeah, well, bracket Buglugs. The complainant, brackets Buglugs. And we, what was that, and whether or not there were actual disciplinary consequences that stemmed from that in the context of their obligations under our code of conduct or our values and those sorts of things. We similarly, questions about privilege in relation to that, and the investigation being done for the purposes of advice about this is what Buglugs has done, and these are the potential disciplinary consequences, and this is what you should do about that. When you get to the end of that, if the person is exiting, I often, when it's a crisis type scenario, you want to think about how that's communicated. Buglugs has left the organisation to pursue alternative opportunities for nobody. And everyone's like, oh, it turns out it was Buglugs' fault. And sometimes that also sends an adverse message, which is we all know it was their fault and they got away with it, and the company's done a deal with them, and this communications says that, which particularly in our sort of workplace safety, sexual harassment, workplace behaviour space may not be the message that you want to send. You may actually want to send the message of, if people behave in this way in our workplace, it's not okay. And then you've got, questions about defamation, which I come and talk to Yudi and his team about, or have we defamed this guy? No, clear all of it. Questions about confidentiality, involvement of the person who's raised the complaint, if it's workplace behaviour and those sorts of things. But I think the days of just, we'll do a deal and they'll go quietly in some of those spaces.
The defamation goes the other way when you've got people putting stuff on Facebook and all sorts of social media, and then we get asked, oh, we're being defamed, what can we do about it? Do you really want to be airing this in the Supreme Court? Victoria, I doubt it.
Well, and equally, if the message that's out in the workplace is, Buglugs got away with it and they paid them to go away. No lie. Yeah.
Alex, can I ask you, if the regulator's already not aware of this, do you then go to the regulator and fall on the corporate sword, or what would you be recommending at this point?
So maybe the access request might not yield all that information to the individual and their lawyers. If we try to
find a way to not disclose it, or some exemption or some argument about personal information and it not being personal information. But ultimately, if this hits the regulator has a lot of powers to ask questions, make inquiries, and the regulator has much stronger powers now since December last year, where the OAIC was granted the full range of powers under the Regulated Powers Act 2014, similar to ASIC or other regulators. Particularly, it can enter premises, access computers, take extracts, ask questions, summon a person to give evidence, and if you fail to comply, that starts attracting criminal responsibility. So, would we go to the regulator? I think we should not really try to. There comes a point where you must conclude that this is not worth hiding. The risk of this coming out one way or another, and the whistleblower is already there in the public domain. It's just too high, and we should probably start working with the regulator to fix it and admit to an extent something's gone wrong. And each time we engage some third-party technology, we need to understand how the magic happens. It's our responsibility. We cannot just rely on this. Oh, it recognizes faces. This one does it. That's brilliant. It's not personal information because the face is divided into segments, and the segments are converged. It's not really a face. It's only zeros and ones. No, it is personal information, and so we have the responsibility. We are deploying it. We are applying it at people. So we need to comply with the principles. So even if the profiling happened out of the US, we need to ensure accuracy of the information and so on. So I just don't see how we could possibly avoid that liability, and rightly we should.
Your recourse back to the US or China or wherever you're getting stuff from is not necessarily going to be any good. Like disappeared, or who knows what they are and what they're...
You can't push it out of jurisdiction and think, oh, that deals with the compliance. That's not how it works, because it would entirely defeat the objects of the Privacy Act, which is something the Commissioner keeps stressing lately, and I guess a strategy for enforcement will be very much based on achieving those objects of the law.
So on the contrary, Charles, sorry, I'd like to bring you in. Far from pushing the liability question out, can we talk about piercing the corporate veil and potential liability for directors?
Yeah, I mean, this is something that's quite specific to my area of practice, because the Food Act of each state and territory only has criminal penalties. They don't have civil pecuniary penalties. And some of the clients that Claire, you referred to me, have also fallen afoul of biosecurity acts, which also have criminal penalties. And like nearly every regulator has both civil and criminal penalties. And for the most part, they choose to only use the civil ones because it's a lot of burden of proof, and it's easier to issue kind of parking fines than to take someone to court and win a criminal prosecution. But food regulators don't have that. They can either let conduct go or pursue criminal prosecution. And I'm hearing more and more, not just from my clients, but also from barristers that I'm briefing, is that food regulators, and this includes municipal governments, are now deliberately separately criminally prosecuting every individual director of a food business to stop the food business from phoenixing, and also because it gives them better leverage and often ends up in a better settlement outcome. And they can do this because, I'll defer to you to hear, this is reaching back 20 years ago to law school, but the corporate veil is no protection against criminal prosecution against the corporate entity. So if you are a director of a corporate entity and that entity is criminally prosecuted, you can be separately criminally charged.
And even if it's not criminal, civil, having the regulator come after you for civil penalties is not pretty either, and it's not a space that you want to be finding yourself in.
Yeah. I mean, one of the ACCC penalties that I've seen enforced is being banned from running a company ever again as an individual. So.
And we see it in our space, in the workplace safety space too, and now, things like psychological, psychosocial safety, sexual harassment complaints, those sorts of things that lead to, the worst possible outcome, people taking their own lives. Well, there's industrial manslaughter legislation and criminal liability in that. Someone has died as a result of that not being properly dealt with and managed. Marcus from our team is up at the back of the room. Spent a bit of time in the Ballarat court the other week in the criminal safety space. So yeah, it's hanging out.
It's real stuff.
Yes, I think we're tracking pretty well. We're a little bit behind, but let's take some questions if there are any. Jump in. Let's grill the panel.
Everyone's been devastated.
We need to go up to room.
This was worst case scenario.
You're sending discovery text messages up to him. Can you elaborate on what sort of text messages now with social platforms like Messenger or WhatsApp? Are these included in the
Any communication can be discoverable. So it's not like, we'll take it off our email and then put it on our WhatsApp and put it on our Messenger. Anything, so long as it would be discoverable, for those that don't know, in court proceedings, documents that could either help or harm your case. The more difficult ones are the ones that will harm your case. You need to produce to the other party. Apologies if everybody's across that, but historically that would have been, paper, and I've done discovery in big litigation where we sat through hundreds of boxes just looking through paper, and then that's moved digitally and all done through sort of sophisticated computer programs, but it's not limited to your emails through your work thing, and they will call for anything, and if there's a whiff, and it might be the regulator as well, it's not just the other side in litigation, that there's some form of communication that is vulnerable. So I never put anything anywhere as a litigator, having seen this stuff. Obviously you have to live and be normal, but particularly if there's an issue, you need to be really, really careful about how that's communicated.
The KHQ Principals Group Chat.
Yes. It's better.
Jodie Hanson.
Yeah, exactly, if you want to know.
I think there is a lot of debate about encryption, encrypted apps, that basically you can't really access it without someone helping you access it, because the provider will say, it's encrypted, that's what we promised to our users, we will never decrypt it. We didn't actually leave a backdoor open to even do that. So many governments have been changing the laws to give them more power to actually force companies to keep some kind of recourse to make data accessible for court proceedings. Ongoing debate. I think the UK passed a reform last year. I think Australia is doing that now.
And there's questions about jurisdiction if you've got things on Facebook and social media where they originate, whether the company needs to give those up. There's been issues around that.
Yes.
Yeah, so the new privacy talk coming in June, will that be a fertile ground for class actions?
Good question. There's already a couple of class actions around privacy, as we all know. I guess the question is there money in it? As crude as that sounds, for someone to run a class action of that size and fund a class action of that size, there's got to be an outcome at the end of it that's worthwhile doing that investment. So I guess time will tell sort of what kind of outcome can be produced. In theory, yes, because class actions are the best placed where there's lots of people, and even if it's only small amounts, you get that email from the bank that says your $126 has now been returned to you. But to go through that process and have the risk involved of carrying a loss and costs and all those things that come with it, and for a funder to make an investment decision, I think will depend on what they can produce on the other end. There may be some firms that are trying to make a name for themselves, and that might run it that way for that reason. Yeah.
Just to add on that, in the privacy space, obviously the class action is very creative because there is no clear claim. So the causes of action include breach of contract, negligence, misleading and deceptive statements, and obviously breach of the Privacy Act. But now we also have the statutory tort of invasion of privacy. Obviously, we have to prove intent or recklessness there. It has to be serious as well. And last year in Victoria, the County Court firmly recognised the common law or equitable tort of interference in privacy, invasion of privacy. So those will be new avenues that we haven't seen explored yet in Medibank, for example. And plus the reform, the recent reform changed things slightly because now after the regulator makes its determination, finds that there was an interference with privacy under the Act. Now even the complainant, the person, can take that to the federal court to enforce it, and the court has powers to change awards, to increase awards perhaps and compensation. So the future class action in privacy could actually be just taking the regulator's findings and trying to inflate the compensation that is due, appealing to the court's better nature.
which is a great point because very often class actions follow from regulatory action. There's a finding, there's a regulatory finding, there's an ACCC finding, there's an ASIC finding, and then all of a sudden the firms are swarming and fighting each other over who's going to bring it.
Absolutely. And wherever you've got an inquiry or a Royal Commission or a regulator's hot to go, the class actions will follow. I'll share this with everyone. I mentioned this at a seminar last week. At present in Victoria, there are 38 class actions before the Supreme Court. They're described as group proceedings, collectively class actions. So 38 currently in the Supreme Court. In the Federal Court, there are currently 146 first instance representative proceedings. That's what they call the Federal Court, again class actions. It's 146 nationally, but 80 of them are in Victoria. 57 are in New South Wales. So as we speak, or certainly this time last week, 118 live class actions were taking place in Victoria, and they related to a whole range of issues, including cyber breaches and data privacy issues, governance services, financial risks, securities, I can't remember if I mentioned, market risks, product liability. So it's a full gamut, and it's here. It's well and truly.
And the funders are very sophisticated.
Very.
Their funding model is very sophisticated, and then there are others that want to get in and don't have such a sophisticated model, but they're prepared to fund things that others maybe wouldn't. So,
A new end. Any other questions? I note the time, as we like to say in court. Will you please join me in thanking our esteemed panel, Alex Dittle, Claire Brown, Yudi New and Charles Fisher.
Gabby, who's made the time to come tonight and